All right, good morning, everyone, and thank you to those of you who responded that you could hear me. We appreciate that very much. We're going to go ahead and get started. So thank you for waiting, and welcome to our online presentation on trusts, powers of attorney, conservatorships, life estates, and vestings. My name is Yolanda Hensley, and I will be your facilitator for today's webinar. Our Senior Vice President of Operations, Christian Fisher, will conduct the training and answer any questions that you may have. Christian is a member of our executive team, and he works directly with our title, settlement, and sales teams. He has a wealth of knowledge and experience in all topics relative to the reverse mortgage industry, and we are extremely happy to have him here with us today. This is a certified reverse mortgage professionals credit course. Please note that due to SB 133, the CRMP credit is not available to California residents. At this time, please make sure that your mouse is clicked on the webinar. I'd like to stress that in order to receive credit, you must be online and stay in the webinar for the duration of the course. Please do not minimize the PowerPoint, work on other applications, respond to or send emails, or allow your screensaver to activate. Doing so activates the score of your attention level, and you may not register an attention level high enough to qualify for the credit. Within the next couple of days, our team will notify you via email regarding your pass or fail score. In addition, we will also submit the score report to NRMLA for their records. This webinar is in listen-only mode. Your line will remain muted. However, if at any time you have a question, please type it into the questions panel on the right-hand side of your screen. Due to the time constraints of this course, we will answer all questions at the end of the presentation. We appreciate your patience and understanding. You may also request a copy of this presentation and recorded session by emailing clientservices@prclosings.com. But be sure to wait until the end of the webinar to send the email, as emailing during the webinar may affect your attention level score. Now, without further delay, let's go ahead and get started. Christian Fisher, everyone.
Hello, everybody. I'm glad you joined us. So today we're going to be talking about trusts, powers of attorney, conservatorships, life estates, and vestings. And these topics are all part of the larger or more general category or idea of estate planning. And before we start moving through the slides, I want to take a moment to mention a couple things about estate planning. First, I just want to make it clear that I'm not an attorney, and this presentation is not intended to be any sort of legal advice. Rather, it's just a means for sharing our experience and things we've learned from a title and settlement perspective in the reverse mortgage industry. Now, the more we all learn and understand about these kind of topics, the better. But if you're working with a borrower who needs legal advice, my recommendation every time is that you refer them to their attorneys and tax advisors for any specific advice. It's also important to remember that estate planning, which borrowers have in place already, was put in place for a reason, and we should all remember to give that the reverence that it deserves. It's also worth mentioning that estate planning is about more than just these topics, but as mentioned, today we're going to be focusing on trusts, POAs, conservatorships, life estates, and vestings. Now let's get started with trusts. So a trust is basically this, it's a relationship created at the direction of an individual in which one or more persons hold the individual's property subject to certain duties to use and protect it for the benefit of others. So you'll often see a trust created alongside a will and other documents. Trusts are typically maybe about 15 to 20 pages, but they can be shorter or much longer than that, just depending on how it was set up. People create trusts for a variety of reasons. It could just be that they want to avoid probate for their estate when they die. Another factor is tax implications, perhaps relating to potential estate tax or capital gains tax, or even community property issues. There's different types of trusts, including living inter vivos trusts, which may be revocable or irrevocable. There's testamentary trusts, special needs trusts, and other sorts of trusts. You'll often hear of trusts referred to as inter vivos or living trusts, and that simply means that it takes effect while the trustor is alive. Now, trust can either be revocable, which means it can be changed or even revoked by the trustor, or irrevocable, which means it can't be changed. And sometimes trusts start out revocable, but become irrevocable at some point, such as upon the death of one or more of the trustors. Now, how trusts affect reverse mortgage transactions. So the trust needs to meet state, lender, HUD, and title guidelines for reverse mortgages, and keep in mind that these sometimes change over time. And trustee and borrower must sign documents. So oftentimes the trustee and the borrower are the same person, but not necessarily. The trustee signs as trustee of the trust, and then the borrower must sign as an individual. This is something that's a lender requirement, but this is something important to keep in mind because it'll come into play when we talk about powers of attorney and conservatorships later. Now, some title and settlement needs related to trust. We look for a full copy of the trust and any amendments. You'll want to advise title or settlement if there are any deceased or incompetent parties. Trust certifications allowed only in certain states or certain circumstances. So trust certifications are basically an abbreviation of the trust, and we typically see these provided in California and Arizona. But the reason we ask for a full copy of the trust and any amendments is the trust cert often doesn't have all the information necessary for a review, especially if there are any deceased or incompetent parties. And keep in mind that title will review for title insurance purposes only, and then the lender will review for lender and HUD guidelines. Trusts basically have three parties. You've got the settlor or trustor. This is the creator of the trust. And of course, this is typically our borrower. Then you have the trustee. That's the fiduciary who's authorized to act on behalf of the trust. And the trustee can really be anyone as long as they're 18 years of age or older, and they'll be signing the loan documents as trustee. It may be that the trustee is our borrower, but the trustee could be someone else, even maybe somebody who isn't related, just depending on how that trust was set up. And then you have beneficiaries, which is normally the settlor or trustor, but beneficiaries are broken out into the immediate beneficiary and contingent beneficiaries. The lender requirement is usually that the immediate beneficiaries must be our borrowers and only our borrowers, and then contingent beneficiaries, usually become beneficiaries upon the death of the settlor or trustor. So, for example, contingent beneficiaries might be the children of the settlor or trustor. Trust checklist. So these are items we look for, as well as your lender looks for when reviewing a trust. All borrowers must be immediate beneficiaries. All immediate beneficiaries must be borrowers, which is a lender requirement. We look to make sure that the correct trust was received. So if the property is vested as Christian Fisher, trustee of the Christian Fisher Revocable Trust, dated October 21st, 1985, but the trust presented for review is the Fisher Family Irrevocable Trust, dated December 2nd, 1990, Mr. Fisher may have given you the wrong trust for review. We look to verify trustees. The trust document itself identifies who the trustees are, and we'll need to verify this because they'll be signing the loan documents. We look to see that the trustee has the power to borrow. We look for a signed and notarized copy. So sometimes people go through all the trouble of having a trust created, but they'll forget to sign and have their signatures notarized. We look for it to be revocable for HECM loans, depending on the lender. Irrevocable is acceptable to some lenders. So some lenders may approve an irrevocable trust, but they may have different guidelines or requirements related to it. So if you notice a vesting says it's in an irrevocable trust, you may want to inquire with your lender first, or perhaps send a copy of the trust to your lender and title company up front for a pre-review. It's also important to note that trust guidelines for lenders change over time, and lenders may require attorney opinion letters or other things related to trusts, depending on their circumstances. From a title insurance perspective, we do our approval or denial for title insurance purposes only. Now, in the case of a deceased trustee, we need an original county certified death certificate, depending on the state. Now, this does vary by state, but usually an affidavit change of trustee needs to be recorded along with a county certified death certificate in the case of a deceased trustee. And then closer or settlement officer will notify of any vesting change. So since vesting will usually read something like John Smith and Jane Smith, trustees of the Smith Family Irrevocable Trust, dated April 29th, 1992. If John passed away, the vesting would need to change. And keep in mind, you also sometimes have changes in trustees for reasons other than death, such as perhaps incompetence, or even simply that the trustee has officially resigned as trustee of the trust. Bottom line suggestion here is just make sure you communicate with the settlement officer to make sure everyone's on the same page and so that the documents are drawn correctly. Now, in the case of a deceased settler, the trust may divide into subtrusts. So this is what's sometimes referred to as an A and B trust, and then one or more of the subtrusts may be irrevocable. So you may have a husband and wife as settlers of an A and B trust. One of the two pass away, and now a portion may lie in the B part or irrevocable portion of the trust. Depending on the circumstances and lender guidelines, it may matter which portion of the trust the home is now in. So you may see lender requirements for attorney opinion letters. In situations like this, it's best to check with the lender and see what they will require and with the trust attorney. A lot of times these kind of trusts are set up sort of vague in the way that they work because they sort of keep options open for the settlers to deal with their property in different ways depending on their circumstances at those times when people pass away. So it's not always clear from reading through the trust exactly what happens to which portions of the trust when somebody dies. It's purposely set up so that there's options there. Now, in the case of an incompetent borrower or incompetent trustee, successor trustees would sign in the event that the trustee is deemed incompetent. And then attorney in fact or conservator could sign on behalf of the borrower as an individual. So this harkens back to the beginning of the presentation where we talked about how you're dealing with two kinds of signatures, trustee and borrower as an individual. If the borrower was the trustee but is now incompetent, you have to look to the trust to determine who the successor trustee or trustees are. And then also the borrower who is incompetent won't be able to sign as an individual. So if there is a power of attorney in place, the attorney in fact could sign for the borrower as an individual, or if there isn't a POA in place, a conservator could be appointed by the court who could sign and take care of that borrower as an individual signature piece. We're going to talk more about conservatorships in a bit. Some possible trust vesting issues. So maybe we're missing maybe the trust is missing or pages of the trust are missing. We could even just be missing page 5, and that page, for all we know, could have pertinent information about the trust. So we want to make sure we have all the pages and any amendments to review. Or sometimes you have that situation where the borrower can't find their trust. They may need to go back to the attorney who prepared the trust for them, who may have kept a copy. Or maybe that attorney could help them with some sort of a restatement or something, or some way to be able to move forward with that lost trust situation. But there again, that would be a situation for an attorney to give them assistance on. Sometimes it's a possible irrevocable trust, which depending on the lender guidelines and situation may or may not be able to approve. Or maybe it's a trust, but the title still reflects just the individuals on title. So maybe the borrower has a trust, but they never deeded the property into it. Depending on the circumstances, we might be able to get a deed from the borrower as an individual into the trust. And what about trustee names not included in the current vesting? So the vesting for a trust really should include the names of the trustee as part of the vesting. It shouldn't just include the name of the trust. So in a situation like that, if somebody's deeded into it without that correctly being stated, then this is the kind of thing that could be corrected with a deed. Or maybe the trust was amended and restated, but that isn't reflected in the current vesting. So we may need a deed from the trustee of the trust as it had been into the trust which was amended and restated on a particular date. And then how to execute the documents. So your vesting is going to be something like this. John Smith and Jill Smith, trustees of the Smith Family Trust, dated 7/29/2011. And then your signatures are just going to be John Smith, trustee, and Jill Smith, trustee. And it's important to note that they must include the word trustee in their signature. Now, some possible reasons for trust denial. Maybe it's irrevocable, and it's a situation where the lender won't approve it. Maybe was only provided a trust certification with insufficient information or deceased party. So if we're only provided a trust cert and not a full copy of the trust, we may not be able to approve for title insurance purposes, especially if there's any deceased or incompetent parties involved. or maybe it was an incomplete copy was provided, or maybe it's one of those A and B trusts involving a deceased party, and depending on the lender requirements, they may have some sort of requirements related to attorney opinion letters or other requirements before they're able to approve. Maybe the trust gives no power to borrow, or maybe all the borrowers are not immediate beneficiaries, or immediate beneficiaries are not the borrowers. Maybe the copy provided for review wasn't executed. Or maybe it's even just time for the trust to be distributed. So sometimes people are so used to a property being in a trust, they expect to handle a new transaction within that same trust. But if events have transpired such that the terms of the trust call for the trust assets to be distributed, then closing a new transaction in that trust wouldn't work.
Thank you, Christian. So this is a gentle reminder for those who are attending for the CRMP credit. This is a gentle reminder that this is a certified CRMP course and credit will be given to individuals with a passing score. You must score a high attention level to receive credit for this course. Here are a couple of tips to help you improve your score. Make sure the webinar is always the active window. Do not minimize the webinar window. Do not navigate away from the webinar to work on emails or other applications, and be sure to type any questions that you may have into the questions panel.
Thanks, Yolanda. We try to add these slides in here because this attention level score is something that's out of our control. It's just part of the webinar software, and we feel really bad if somebody attends for credit and then they don't register a high enough score, and there's nothing we can do about it. So we try to throw these reminders in there to keep everybody reminded of that fact. So thank you, Yolanda. And moving on to powers of attorney, but before we do, just a reminder that we'll be answering questions at the end of the presentation. So if you have any questions regarding trusts, be sure to enter those into the question log. So power of attorney, it's basically just a legal document appointing another person to manage the principal's financial affairs. There's some different reasons or potential future uses for powers of attorney. Maybe a mentally incompetent principal, for example, somebody suffering from dementia, or maybe a physically incapacitated principal. Maybe they're physically unable to sign for some reason, or maybe they're competent but they prefer not to sign, or maybe they'll be out of the country or they just simply prefer not to sign. If you do have a situation like this, though, you want to be sure to check with the lender as well as title to into any requirements related to counseling, signing of the loan application, those kind of things, and they'll want to know the reason why a POA is being used in a scenario like that. And here's just a visual representation of an example POA. I'm sorry, it's hard to see, but on the left-hand side there's a number of different lines, A through N, and then to the right of those lines are powers being granted. So in this example, signing line N grants all the powers listed above it. And this is the kind of place where we look at a POA document to see if it grants the power to deal with real property as well as other powers. We also look for durability language, and this example says, this power of attorney will continue to be effective even though I become incapacitated. And this is what makes the power of attorney durable. Now, for a real estate transaction, financial POA is required. We can't utilize a medical POA for a real estate transaction. And the original POA is required at closing or prior to, and must record with the mortgage or deeds of trust if the POA is not already recorded. This is very important to remember. If you have a loan where a POA is going to be utilized, you want to establish up front and make sure the original is located, because we will need it to record if it hasn't already been recorded by the county recorder in the county where the property is located. And that's important because in order for the POA to be used for real estate transactions, it must be recorded. Often we're provided with a copy to review and told that the original will be provided at closing, but please be sure to reiterate with your borrower that if the original is not provided at closing, their loan won't be able to be funded. And of course, sending the title up front is a better practice. After it is recorded with the loan documents, it will be returned to them. And then an alternative, if you're working with a borrower who is leery about giving up their original, is that the borrower can actually take the original to the county himself and have it recorded, and then just get a copy of the recorded one to provide the title. Now, some different types of POAs. You've got a standard POA. This is effective upon signing, doesn't have durable verbiage, and lenders may reject a standard POA if the borrower is unable to sign the loan application. Now, we don't see standard POAs nearly as often as we see durable POAs. Durable POAs continue to be effective even after a borrower or a principal becomes incompetent. And then there's something called a springing POA, which only becomes effective after the principal becomes incompetent. We see these most often on the West Coast. It could be a situation where I want to make sure someone is able to handle my affairs should I become incompetent, but I don't want them to be able to do so until I become incompetent. In the case of a competent borrower, a durable or standard POA is normally acceptable, but must be reviewed to ensure that it meets guidelines. The competent borrower must be counseled and sign the initial loan application. Those are typically the lender's requirements. And then principal's affidavit signed and notarized by the borrower settlement to provide. So the principal's affidavit is important. As a way of preventing fraud, we require an affidavit from the principal, which must be signed by the principal and notarized, confirming they're aware that the POA is going to be used to sign reverse mortgage loan documents for their property. This document can't be signed by the attorney in fact. Now, keep in mind, this is in a situation with a competent borrower. We do also have a separate affidavit of attorney in fact for the attorney in fact to sign. Now, in the case of an incompetent borrower, either a durable or a springing POA may be acceptable, but must be reviewed prior to approval, and may need 1 or 2 letters from a medical doctor to demonstrate that the borrower is currently incompetent. So the power of attorney document usually specifies how many doctor's letters are required. But if it doesn't, our company policy, for example, is 1 doctor letter when the document doesn't specify. Now, some requirements for a doctor's letter. It should be on doctor's letterhead. It should be dated, have the doctor's signature, and include verbiage, something along the lines of that the party can no longer handle their financial affairs. Now, depending on the situation and the timing of events, you'll also see lenders require doctor's letters to address the competency of the principal at the time the power of attorney was executed. So if it was recently executed, but now the borrower is incompetent, if there's concern about the proximity and time of those 2 things occurring, you're going to see requirements related to those kind of situations. Now, what a POA can't do. So in most cases, it can't be used for self-serving purposes. So for example, if I'm the attorney in fact for, let's say, my brother, I can't use the POA to deed his property to myself. And it can't be used to sign on behalf of a trustee unless both the POA document and the trust specifically allows for it. And you don't normally see where the trust and POA documents specifically allow for this. So while it is possible, it's very unlikely. So a good rule of thumb to remember is that trustee signatures can't be signed by the trustee's attorney in fact. All POAs must have the following. So we look to see that it has the power to deal with real property, the power to borrow, mortgage, encumber, or hypothecate. And sometimes in some states, reference to certain probate codes will just automatically mean that the POA includes these powers. We look for it to be properly signed, notarized, and witnessed, if applicable. That varies by state. And this is important to remember because we have to be able to record the POA sometimes after closing. And if there's something wrong with the signature or notarization of the document, it could be rejected by the county recorder. Now, how to execute documents. So your vesting is going to be something like Sally Borrower, if the borrower is Sally Borrower and then the attorney in fact is Joe Agent, you're going to have Sally Borrower by Joe Agent as her attorney in fact, and that needs to be spelled out. Some possible reasons for POA denial. Maybe it lacks the power to borrow. Maybe there's something improper about the notary acknowledgement. Maybe it's got a lack of durability language, which states this power of attorney continues to be effective even though I become incapacitated. Maybe there's something invalid about the signatures, or maybe it's got a lack or insufficient number of witnesses. So, for instance, in Connecticut, you have to have witnesses, and there's some other states that require witnesses as well. Or maybe it's a springing POA, but the borrower is still competent. You wouldn't think somebody would try to do a transaction this way, but we've had it happen a number of times before where a springing POA was presented for approval, but the borrower was competent, so that POA had no effect yet. Or maybe there's insufficient doctor's letter or letters. Maybe the POA form itself doesn't conform to state guidelines. So there's some states that have statutory forms which must be used, like New York, for example. And then there's some states that have statutory forms available, but they aren't necessarily mandatory. Or maybe the original POA is missing and it hasn't been reported yet by the county, then that would be a problem. Or maybe there's an issue with the principal's competency at the time of execution, which we kind of covered that a little bit before, but you'll see requirements related to those sort of things. Now, before we move on to conservatorships, just some closing remarks about POAs in general. Because of the demographics of the borrowers in the reverse mortgage industry, we see significantly more POAs used in our transactions as compared to the overall mortgage industry. And POAs are legitimate, useful things and very important in transactions in certain circumstances, but they can also be a red flag. Just the mere existence or use of a POA in a transaction can be a red flag for potential fraud. So it's important to be very careful, scrutinize more, watch out for anything that might be inappropriate whenever you're involved in a file that is using a POA. You want your radar to be up even higher, watching out for anything inappropriate, potential elder abuse or anything fraudulent, all those sorts of things.
Thank you, Christian. This is a gentle reminder that this is a certified CRMP course and credit will be given to individuals with a passing score. You must score a high attention level to receive credit for this course. Here are a couple of tips to help you improve your score. Make sure the webinar is always the active window. Do not minimize the webinar window. Do not navigate away from the webinar to work on emails or other applications, and be sure to type any questions that you may have into the questions panel.
Thanks, Yolanda. And so we've reached the end of the section on POAs, so if you do have any questions about those, be sure to enter those into the questions panel, and we'll get to those at the end. And then we're moving on to conservatorships. So conservatorship is basically, it's a court action designed to protect the interests of a person determined to be incompetent. And a conservator must be appointed for the estate if a real estate transaction is what's being looked at. So a conservator is frequently appointed for the borrower's person, for healthcare, and estate for property. Conservatorship is sometimes referred to as guardianship in some states, but in other states those are two separate things and they mean two different things altogether. Something like a conservatorship may be needed in order to sign on behalf of an incompetent person where a POA had not been created and executed by the person prior to their becoming incompetent. And conservatorships take time because they're done through the courts. Now, the court must approve the reverse mortgage, and normally this is done by an order. Title and settlement will need a copy of the letters of conservatorship as well as the order approving the reverse mortgage. And if the letters of conservatorship or the court order authorizing the reverse mortgage haven't been reported by the county recorder, then we may require an original or court-certified copies for recording. And it's important to note that the court has to specifically authorize a reverse mortgage and not just a mortgage. And it's best if it doesn't specify an exact loan amount, since we know that can change or it can be a misunderstood concept as it relates to reverse mortgages. Now, the letters of conservatorship document is what identifies who the conservator is, and that's the person who will be signing the loan documents. Now, how to execute documents. So your vesting is going to be something like this: Jane Smith, conservator of the person in the estate of John Smith, conservatee. Sometimes that vesting will even list out the court case, number and things like that. It just kind of varies on how it was set up. And then your signature is going to be Jane Smith, conservator, or even simply Jane Smith. Now, that whole vesting, about conservator of the person in the state of, et cetera, can all be included in the signature lines, but for title insurance purposes, we really just need Jane Smith, conservator, or even just Jane Smith as the signature. Signatures on documents when a conservatorship is involved is one area that we see quite a bit of confusion about. or sometimes even errors in the way the documents are drawn. People have a tendency to want to treat it like a POA situation and want to show it like John Smith, conservatee, by Jane Smith, his conservator. But that's not exactly the right way to do it. The conservator isn't exactly using a power to sign for the conservatee the way an attorney in fact is under a POA. The conservator is simply, as the conservator, signing the documents. And this marks the end of the conservatorship section, so take a moment to enter any questions on those in the questions panel.
And again, for those of you who have asked questions, just want to remind you that we will be answering those at the end of the webinar, just due to time constraints.
And we're moving on to life estates. So what is a life estate? It's basically a type of ownership arrangement for real property where one person, the life tenant, has the right to use the property until they die, and then another person or persons, the remainderman, gets the property when the life tenant passes away. So sometimes people will create a life estate, maybe through an estate planner, as a means of having their property avoid probate when they die. It's kind of like granting a future interest in their property to someone else, but reserving a life estate for themselves to be able to live in and use the property for the rest of their life. Now, life estates may be either granted or reserved in a deed. And let me explain what I mean by this. So an example of granting a life estate interest would be, let's say I own a house and I want my parents to be able to live in it and use it for the rest of their lives. I could draw up a deed granting that life estate interest to them. But as an example of reserving a life estate interest in the deed, let's say my parents owned their house and they want to continue to use it and live in it for the rest of their lives, but they want it to go to me when they die. They could deed the property to me now, but in the wording of that deed, reserve for themselves a life estate interest. Now, a life tenant must be, and the life tenant is the person who has the life estate interest. The life tenant must be our borrower, and then the remainderman can really be anybody, as long as they're 18 years of age or older. The remainderman is the person who gets the property when the life tenant dies. Now, there can be multiple remaindermen, and the term is not gender specific. Now, both the life tenant and the remainderman will need to sign loan documents. Now, liens incurred by the remainderman can attach to the property, though this does vary by state. And what if the remainderman passes before the life tenant? Life estates may seem straightforward, depending on the order of things happening, but they can really be actually tricky and have unintended consequences. So the interest of a remainderman who predeceases the life tenant would actually pass to the remainderman's heirs unless his remainder interest was vested in the survivorship vesting amongst other remaindermen. Now, there are such things as enhanced life estates, sometimes called ladybird life estates, that exist in certain states, especially Florida and Texas. And they're similar to regular life estates, but they differ in that the life tenant actually retains the power to sell or mortgage the property without the joinder of the remainderman. And also these sometimes avoid liens of the remainderman from attaching prior to the death of the life tenant. It's important to note, though, that even with an enhanced life estate, the lender often requires the remainderman to sign the loan documents anyway. Now, to try to contrast life estates with transfer on death or beneficiary deeds, so there's some states, a couple that come to mind are Arizona and, relatively speaking, a fairly recent one in California, have versions of beneficiary deeds or transfer on death deeds. And they have certain rules around them, but generally speaking, they don't affect the vesting until the grantor dies. And generally, the grantor can revoke or change them prior to death. Now, there can be differences in ramifications for future Medicaid qualification between these different kinds of deeds and ownership arrangements, which is just a reminder of the importance of those seeking advice about these to consult with their attorneys, estate planners, and tax advisors. Also about those transfer on death deeds, like if you take that one in California, for example, it was created by, statutorily, and it was set to only exist for a certain period of time unless it gets renewed. And the general sense that I get from just talking to different attorneys and things like that about those deeds, it feels like there's a lot of trepidation surrounding those, but it makes for interesting change of title sometimes, and something that's interesting. Now, how to execute documents. So if your vesting is John Smith as to a life estate and Susie Smith as to remainder, then your signatures are just going to be John Smith and then Susie Smith, comma, remainderman.
All right, this is another gentle reminder that this is a certified CRMP course, and credit will be given to individuals with a passing score. You must score a high attention level to receive credit for this course. Here are a couple of tips to help you improve your score. Make sure the webinar is always the active window. Do not minimize the webinar window. Do not navigate away from the webinar to work on emails or other applications. And be sure to type any questions that you may have into the questions panel.
And as you're jotting down any life estate questions you have there in the questions panel, we're going to start moving on to the vesting section. So common vesting. So if you hold title to property by yourself as an individual, that's pretty straightforward. It's just your name, and depending on the state, it may need to state your marital status. But if you hold title along with other people, it should specify a vesting to define the manner in which you're holding title. So there's some of these common vestings in addition to things like trusts and life estates. You have tenants in common, joint tenants, community property with right of survivorship, tenants by the entirety, and then you have properties owned by partnerships, corporations, and LLCs. We'll start with tenants in common. So tenants in common is ownership by two or more parties. It can be divided into any number of interests, equal or unequal. So you could have one party with 99%, one party with 1%, or 100 parties each with 1%, or whatever. And each party can transfer its/his/her interest without participation of the other parties, and they can leave their interest in a will. Tenancy in common can generally be thought of as the default vesting if two or more names appear on title and no other vesting is specified. And you also have joint tenants. Now, this is two or more persons, not artificial entities, with equal interest in the property. And usually joint tenancy has the right of survivorship among the joint tenants, though sometimes this must be stated with certain verbiage, and that varies by state. So what right of survivorship means is that when one joint tenant dies, his or her interest in the property goes to the remaining joint tenants by operation of law. Now, if one of the joint tenants conveys his or her interest without the others, doing so may sever the joint tenancy. And that's a situation that can get tricky at times or have unintended consequences, because depending on where that appears in the chain of title, if someone severed a joint tenancy and then somebody passed away, then maybe what they were expecting to happen to the ownership of that property might be affected by the fact that they had severed that joint tenancy previously. Another vesting is community property. This is two people married to each other, or in certain states, if they still have these regs on their books, domestic partnerships. And community property as a vesting doesn't necessarily have the right of survivorship. That depends on the state, the circumstances, and whether the deceased party had a will that left some of his or her interest in the property to someone else. Sometimes if that person did have a will, it may be that half of the deceased person's interest passes to the surviving spouse, and the other half of that deceased person's interest passes to whomever it was willed to. Now, there's also a vesting in certain states called the community property with right of survivorship. And this is basically the same as community property, but also has the same right of survivorship like joint tenancy does. And this vesting is only available in certain states. California is one of those. There's also a vesting called tenants by the entirety. And here again, this is two people married to each other. And usually this has the right of survivorship, though here again, sometimes this needs to be spelled out and stated in the deed. Now, in certain states, this type of vesting is actually the assumption if the people on title are married to each other and a different vesting isn't specified. And in some states, with this type of vesting, a judgment against only one of the two spouses won't attach to the property. And so for some people in situations, that can be a handy feature. And then sometimes you'll see property that's owned by partnerships, corporations, and LLCs. These are all artificial entities. And of course, you couldn't close a reverse mortgage transaction in any of these entities, but you may come across these if your borrower is maybe holding their, title to their property in their partnership or corporation or LLC. But a partnership is created by a partnership agreement. Corporations and LLCs are created by filing articles of incorporation with the Secretary of State or other appropriate state agency. So if vesting in a file that you're involved is in one of these entities, title and settlement will need certain documents for review, and they'll advise on any other specific documents needed for that particular file. But there again, you wouldn't be able to close a reverse mortgage transaction in any of these entities. And before we jump into the questions section, just look at the time. I want to take just a minute to bring up something that's off topic, but it's important to our industry. So any chance I get with a soapbox of any kind, I try to mention this. Something we all need to watch out for, warn our partners and borrowers about, is email fraud and wire fraud. So scammers are using increasingly more sophisticated schemes to trick people into wiring funds to the wrong place. Even if our system and your system is very secure, scammers could have compromised any one of the other multitudes of parties involved in a transaction, be it borrowers, family members, realtors, etc. And then with information about the transaction, they can wait and launch a well-timed fraudulent email that appears to be coming from someone legitimate, instructing funds to be wired to the wrong account where the money will disappear. So I suggest all of us be very suspicious of every email you receive, but especially if it has anything to do with money. Don't open attachments, click on links, or enter any passwords if there is even the slightest doubt as to legitimacy. Call senders at known phone numbers to confirm what they send. Warn all borrowers, but especially borrowers who will be coming in with money such as short to close loans or have them for purchase. And you want to expect to encounter strict guidelines related to the acceptance of wire instructions that may even seem tedious or over the top, but are in place for a very good reason. We see even more lately, more instances of altered payoff demands where somehow somebody got in the middle of a transaction and calls the borrower and acts like they're their payoff lender and says, we're sending you a revised payoff demand, or the payoff demand changed a little bit or something like that, and sends a payoff demand with wire instructions that are to not where they need to really go and goes to a fraudulent account. So anything you can think of, scammers are, kind of glomming onto and trying to get in the middle of transactions. So I suggest everyone, even tangentially related to a real estate transaction, be leery of any and all emails that have anything to do with sending money, payoffs, wiring, even if it looks like it's coming from someone you know.
Yeah. Always double check those email addresses. Trust your gut. That's something that we've had a lot, if we've ever experienced those. If something doesn't look right, always question it and always trust your gut. So thank you, Christian. So thank you guys for your attendance. At this time, we're going to be answering any questions you have. Remember to type any questions that you may have into the questions panel, and be sure to remain active in the webinar during this time as your attention levels are still being scored. So give us a moment, please, while we review the questions, and we will get started on those.
Okay, somebody's got a trust question here. They're asking, what is a grantor in the trust? And so usually if something's referred to a grantor in a trust, that would be the settlor or the creator of the trust that's being referred to. There's a question here too, do you have to have an updated POA after a certain number of years? Not necessarily. However, if you try to record, keep in mind you have to record a POA in the county where the property is located in order to use it for a real estate transaction. And if you try to record a POA that's, 30 years old, the odds that it's going to have some sort of a difference in the way that it was notarized back then, maybe in the notary language or something like that, that may cause a recorder to reject it, are significantly higher. So I wouldn't say that there is a specific requirement that a POA be updated after a certain number of years, but it's certainly a good idea if someone is, you know, going through and updating their documents and things like that, if they have a POA that was done a long time ago and they're still in a position to maybe do a new one or update it, or maybe they maybe it's somebody else they want to appoint it now than they did, you know, way back when. It's certainly something that should be considered. There's a question here about doctor's letters and what would make a doctor's letter insufficient. That's where we just kind of talked about the things that you should see in a doctor's letter when it's making that statement that a borrower is, or that a principal is no longer able to handle their financial affairs. It may be that sometimes we'll see doctor's letters that are presented that are supposed to be for that purpose, but they don't really say that. They say other things, or they don't cover what exactly is maybe required by that document that's wanting the doctor's letter, or maybe it's not dated, or maybe it wasn't signed by the doctor. Those kinds of things could be an issue with accepting of a doctor's letter in those cases. But it's kind of case by case on those things. So, if you're in a situation like that, look at the specifics.
Sorry, user error over here. I closed my questions panel.
Yeah, there we go. Let's see. Okay, so there's a question here. It says, if a trust was done several or many years ago and has POA provisions, and the borrower has recently become incompetent, should the doctor letter state that the borrower can no longer handle their financial affairs as of a certain date? Okay, so two things to mention about this question. Keep in mind that a trust itself and a POA document are two separate things. A lot of times people will have them created at the same time, but usually the power of attorney document is different from the actual trust. But having said that, the question itself is, should the doctor letter state that the borrower can no longer handle their financial affairs as of a certain date? And that's where we talked about, especially if the proximity in time is close, you'll often see requirements from lenders or even title to address the borrower's competency at the time that they executed those documents. In this question, it sounds like they did this quite some time ago, but are now incompetent. So I think in that situation, you won't see nearly as much of a requirement related to that because of the things that didn't happen so close together in time. But there again, everything's case specific, so you could see something like that. And if the doctor were to include that additional information about timing, then I can't imagine that would hurt, especially if it supported what was being alleged in that particular file.
Good question.
Okay, let's see. So it says, you may have answered this already, but in a POA situation, does the POA and the borrower need to both be present at closing? It's a good idea. Now, if you had a situation where the principal is incompetent, then the principal, the borrower, isn't going to be signing anything, or can't sign anything or be notarized or anything like that. So as far as the signing piece of it goes, that wouldn't be necessary. However, when a POA is being used, it's still a good idea to have the borrower be present, because oftentimes there's a live and well requirements, especially with lender and even title requirements. At the time that the file closes, the borrower does need to be alive. And so if the borrower can be present, even though they're not specifically signing anything in that incompetent situation, then having them there is a good idea. Now, if it's a competent borrower, then they definitely need to be at the signing, because there's for instance, that principal's affidavit that they'll need to be signed and be notarized on. Someone's got a question about where we talked about LLCs, partnerships, and corporations, asking if they can do a reverse on an entity like that, and the answer is no. You would not be able to close a reverse mortgage transaction in any one of those entities. But you may run across these entities on title in transactions you're working on if maybe the borrower, just happens to have an LLC partnership that they had that title, to that property in. But if they were going to do a reverse on that, they would have to come out of that entity into themselves or their trust or what have you, some sort of an entity that could do a reverse mortgage, but it cannot be done in those entities. Okay, and somebody's got another question about POAs here. So it says, what's the length of time you recommend the POA be updated? And what happens if you have a POA and the person is not competent? Will there be an issue even if it is old? So we kind of touched on this a little bit earlier. There is no specific time frame, and there wouldn't necessarily be an issue, the fact that it's old. It's just that it makes it that much harder to record, which is a requirement. And so if it's a situation where somebody's already become incompetent, then they won't be able to do a new POA at all. So it's not even an option there. But if somebody did, create these documents years and years and years ago, and they're maybe updating some of their estate planning type things, it might be a good idea to create, a new one at that time. But, as far as it excluding it because of a particular age, there isn't such a thing as that unless there's some other problem, like you won't be able to record it for some reason.
Oh, a couple questions for me. Someone's asking if you guys will receive a copy of the slide deck. So we do send those out upon request, and that email address will be on the next slide for you. So wait for that, and we'll have that up for you shortly. And then someone asking if I can be set up for a new webinar session due to IT issues. So we do this CRMP webinar quarterly. So if you are attending for credit, you would have had to have attended and achieved that attendance level requirement to be able to get that credit. We are recording the session, so it will be available later. We can send you the recording. Otherwise, you can register for our next CRMP webinar that we'll have next quarter.
And let's see, there's another question here about POAs and conservatorships. It says, what would flip a POA to a borrower needing a conservatorship? So I guess, in that situation, we talked about how if, the main thing you're dealing with in reverse mortgage transaction is borrower signing as an individual for a HECM, and or even for proprietaries, that's still a requirement. But so if there's some issue with the POA that's in place, maybe it's lost or it can't be recorded for some reason, or there's some reason to believe, or maybe it wasn't approved by title and or the lender, then a situation like that where there was some problem with that POA, that existing POA, then your only alternative at that point would be a conservatorship to take care of that individual borrower signature portion. But there again, those kind of things are case specific. So if there's some sort of a problem or some reason the POA can't be approved, then that's kind of the only alternative at that point.
I don't know if anyone has any other questions. I think that was it. Here's another one. Hold on.
Somebody has a question here. It says it would be great to have a checklist of items that might disqualify a POA or a trust. If you look back in those slides, there were some of those things mentioned in those things, where we look for certain things as part of the approval process. And so the request, when we get to this final question or final panel on the screen, you'll see an email address. You could send us an email and request a copy of those slides.
And I think I do also have like a FAQ, not FAQ, but I think I have some information on what might disqualify a POA as well. So, and a trust. I believe I have two pieces on those as well that I can send you upon request. So let me go ahead and forward this slide. So here's the email address that you can request the slides at. You can request those pieces, any information, any additional questions that you might have.
You can just say hi.
You can say hi, tell us about your day. Client services at prclosings.com. And one last thing before we sign off. I know I've got the question when you register for the webinar to let us know if you are attending for CRMP credit. That I know it's small and can be missed. So if you are attending for CRMP credit, if you wouldn't mind just typing into the questions panel CRMP so that I know. And then I can send you your score once we have that available for you. And I think that's it, unless anyone's got any final questions. And if not, I think that concludes it. So we have reached the end of the questions, and this concludes the presentation. We will be sending a report to NRMLA within the next few days with the list of attendees who met the attention level requirement to receive credit for the course. You may request a copy of this presentation and recorded session by emailing clientservices@prclosings.com. And thank you very much for attending. We truly appreciate your partnership and your business. We look forward to working with you soon in the future and having you attend our next webinar.
Have a great day, everybody.
Yes, thank you so much, everyone. Have a great day.